Ladies and gentlemen, welcome to the Inmate Alliance Insider Broadcast. My goal is to give you the truth about the federal prison system. You may not want to hear it, but I'm going to tell it to you anyways. So I'm here to tell you what those behind the wall need to know and to enlighten those outside the wall. If you're an inmate, former inmate, family member, loved one, buckle up and stay tuned for the truth from one who's been there and really knows what it's like. I'm your host, the one they call the old guy. So let's get started with the latest news of the week here. Restitution is something near and dear to my heart here. Restitution has long been considered to be remedial to make victims whole, rather than punishment. And many defendants who receive a restitution order pay little attention to it, although I do, because they're much more fixated on the amount they're getting rather than the enormous amount that they're ordered to pay. Unfortunately, someday always comes, leaving defendants struggling in many cases with restitution that has nothing to do with what they can afford, how much they made from the offense, or even the losses of the victims. Last week, the National Association of Criminal Defense Attorneys published a report on federal restitution that was detailed, surprisingly, and insightful. Imagine that. The report found that $110 billion of federal restitution debt remains outstanding, with a full $100 billion of that being deemed uncollectible. Imagine that. They take everything from you. They just literally destroy you. And then say, okay, well, pay up. Oh, and be a good person. Don't get in trouble and pay up. So the average amount of federal crime restitution order is more than $3.3 million, including not the full amount of the victim's losses, but often includes calculations and pre- and post-judgment interest as well. In 30% of the restitution orders, the victims incurred no loss, but are entitled to repayment anyways. Imagine that. No loss, but are entitled to repayment. For what? Repayment for what? Restitution hearings can be held after sentencing hearings, and not every circuit recognizes a defendant's right to be present at those restitution hearings, although I have to admit that I was. Ill-prepared, but I was there. There is a pending Supreme Court case called Ellingsburg versus the United States, which may have something to say about that. Courts do not have to apportion liability among defendants. When defendants are found jointly and severally liable, each defendant is legally responsible for the full amount of the victim's losses. It just fries me. Just last week, the Third Circuit ruled that a restitution order where the defendant has stolen from two gun stores was flawed because the stores were awarded the value of the guns and lost sales income from the guns as well. So it's kind of a double whammy. The criminal defense lawyer study recommended that Congress and the Supreme Court should recognize that a restitution order is part of the sentencing process and is therefore a critical stage of the criminal legal process of which the defendant has a right to defend it. That, because a sentencing is focused on incarceration, a separate restitution hearing should be required to specifically address how much restitution should be ordered and to whom. The study also argues that federal restitution statutes should be amended to require judges to consider the defendant's ability to pay. Let me reiterate, the defendant's ability to pay. So when you take away everything from somebody, how much do you think you pay? I mean, even when you're in custody, they require you to pay some restitution. You don't have any income, especially seniors who are on Social Security. You don't have any income whatsoever because Social Security cuts that off. So how are you supposed to pay restitution with no income that the government has already done to you? And when payment is ordered, defendants should only be required to reimburse actual losses. Let me reiterate that. Actual losses. So when you're a co-defendant in an action, and the one guy is responsible for the loss, and the other guy has been convicted of what the Department of Justice likes to call conspiracy, whether you knew about it or not. What is your responsibility for the actual loss? Well, I'm going to tell you it's very little. The study proposed that joint and several liability should be eliminated. Here. I know a bunch of you, Scott and Stanley, and a bunch of us, and would cheer that. We'd throw a party if that one were going on. You mean not only were we were wrongfully convicted because some little pipsqueak prosecutor thought he could make a case so he could pad his numbers, make his conviction rate look good, knowing full well there was nothing there. The chance for any constructive criminal justice legislation with this president and Congress is minimal, and I grant you that. But just last night, the GOJ used, on the direct order of the president, to charge one of his political enemies. So don't expect any defendant-friendly changes in the law anytime soon, even though they make perfect sense. I kind of think that the president might listen, because he has been big in judicial reform and prisoner reform. He was the originator of the First Step Act, which, by the way, the BOP still hasn't figured out how to do. So I do differ from this perspective, and I think that if it were brought to his attention, that he may very well look at it and figure out that there's something to be done, because he's been on the receiving end of some of this garbage too. So it might make sense for the president to kind of look at this thing. Anyways, it's getting some play, it's getting some visibility, and it's something that all of us who have been in this system really need to push. And now the shoe is on the other foot, and oh, boo-hoo. BOP Director William K. Marshall III told employees that the union representing corrections workers has a proud history of advocating for its members. And he went on to acknowledge the positive contributions that they've made over the years. But, big but, when a union becomes an obstacle to progress, let me repeat that, when a union becomes an obstacle to progress instead of a partner in it, it's time for a change. And today, thanks to President Donald J. Trump and Attorney General Pam Bondi, we're making the change. Today, he announced the termination of the BOP's contract with CPL 33 effective immediately. That's the Correction Workers Union. Now, this is important, and listen up here, because this is critical. In the case of Gonzalez versus Herrera, which is number 24-2371, in the Ninth Circuit Court of Appeals, which is out in California, it held that FSA credits can be used to reduce a sentence. That's what it says. You have to have the Ninth Circuit Court of Appeals tell somebody that FSA credits can be used to reduce a sentence. That's what they call additional good time for minimum to low risk prisoners who are eligible for First Step Act consideration and that good time. The court held that FSA time credits in excess of 1 year should be applied to a defendant's term of supervised release. Gonzalez served his prison sentence and started supervised release with an excess of FSA time credits that he requested be applied to reduce the term of his supervised release. Makes sense, right? Another case with the same holding that time credits can be applied towards earlier placement in pre-release custody or supervised release is Valadares versus Ray, which is in the Fourth Circuit Court of Appeal. Despite a growing number of such cases, some institutions, such as Oakdale, continue to slow walk the director's sentence reduction initiative by tampering with the administrative remedy process. Did you hear that? Tampering with the administrative remedy process. And we'll talk about that in just a minute. Especially when filed by non-citizens in full legal status. So, we're trying to make a distinction here, but I'm telling you that these facilities, they slow walk. They do everything they can to slow down the administrative remedy process. They have, by law, certain time limits that they have to respond, and they don't care. So I think, and I believe it's going to get worse since the CO's union has been decertified. So, keep an eye on this. And after losing several challenges to its prior policy, the BOP ceased its prior practice of failing to award FSA credits to non-citizens. Well, they failed to do it not only to non-citizens, they failed to do it to everybody else. But some prisons have resorted to sabotaging prisoner remedy filings, seeking to block their access to habeas corpus, which would be 2241 and 2255 filings. But I think in the interim that those require you to go through the administrative process while you're in custody. And it is a nightmare to figure out how to do that. I was in with some pretty bright people, and we just struggled to find all the different bits and pieces and rules and regulations. So one of the first things I did when I was released as part of my Inmate Alliance offerings is I put together a manual of how to file an administrative remedy. The process. There are 4 levels. And you have to know how to determine how to handle each one, all the time limits, what you can and can't do. And I can't write it for you, but it's showing you what you need to do, how you need to do it, where you need to go. If time limits are violated, what do you do? Because I'm going to tell you, on one administrative remedy I filed, I have yet to hear from the central office on that filing. And it's gone, on 2.5 years now that I have yet to hear on a filing for an administrative remedy to the central office. So this tells you what kind of game they play. But you can proceed, and I didn't know this, when their time limit is up, you've done your due diligence. You can go right to a 2241, 2255 filing with the court system because you have fulfilled your obligation. It just be cognizant. You need to know how to do that. And I'm telling you, with the limited resources that are available to federal inmates, you're going to play hell trying to find those things. So go to my website, go to www.inmatealliance.org, and there is a link to the guide I wrote and how to proceed with an administrative remedy and a compassionate release, because the powers that be in these prisons in the central office, they're in the in their minds, they're in the business of incarceration. They are not in the business of rehabilitation. They are not in the business of fairness by any stretch of the imagination. So remember that. So if you know somebody who is struggling to write an administrative remedy to get their first step back time credits, which is something that they're due and owing, go to my site, buy a copy of my publication, because I'm telling you, I got hundreds of hours in that thing trying to get bits and pieces from all over the place, because you can't find one spot on how to file an administrative remedy. So that's why I put together the guide, because, man, I couldn't figure it out. And I did. The resource doesn't exist to find it. So when you have some pretty smart people working together to facilitate that kind of thing, that it makes it virtually impossible. So anyways, I've done the work, and that is now available. And you go to my website and you can find it. But there are just the basics of this whole thing. That's just the news of the week. But it's an ongoing, enduring problem with the entire federal prison system. That the first thing that they need to do is focus on rehabilitation, because the BOP is the poster child for money-wasting bureaucracy. So, you need to do some things. What is their mission? Their mission is rehabilitation. The mission is to get you ready to go back out into the street when you've completed your sentence. Right, wrong, or indifferent, if you're there, you need to go back out when you finally get out. You have to resume your life. And let me tell you, it's not easy. So what, in lieu of this rehabilitation, or in light of it, what do you think they ought to do? Well, a study came out that the federal prisons, in addition to just about every federal building, is in terrible state of repair. Starting with the Federal Bureau of Investigations building in Washington, D.C., where they have to have nets to protect the people walking on the street because parts of the building tend to break off. That's a maintenance issue. And they let it slide, and by the time you realize it, these buildings are ready to fall down. So the situation from my point of view, is to train moderate or minimum to low-risk inmates for good-paying jobs in the building trades and get their facilities repaired at the same time. What a novel idea. You got a built-in workforce looking for a career when they get out, and you just let them sit there sucking their thumbs, So, get with the building trades, get with the vocational schools in the area. They're all over the country. And make a deal with them to train the workers in building trades: plumbing, electrical, HVAC, roofing, carpentry, bricklaying. I mean, they're all trades that are hurting for people on the outside. So get them trained and get your buildings fixed. The other biggie is to hire a food service director at each facility, or a food service training person at each facility, to teach minimum to low-risk prisoners to be line cooks, sous chefs, or whatever, and all while providing nutritious, good-tasting food. Because I'm going to tell you, not only is there food insecurity at most of these facilities, the food is horrific. It's awful. So, give the guys a good meal, and training people so that when they get out, they can get a job. What a novel idea, since you've taken everything from them. Not you, but the government. These unscrupulous prosecutors and judges who have managed to take everything from people. At least give them a leg up so that when they get out, whether they're in home confinement or in a halfway house, that they can go out and have a readily marketable skill and can get a job right away. But the BOP has a dirty little secret. Hang on here a second. I forgot to turn my ringer off on my cell phone. That serious offenders make up a tiny percentage of the people in custody of the Federal Bureau of Prisons. Seriously. Now, there are some that, simply, or they may be low risk, but they're horrific offenders, and those are crimes against children. But the remainder are everyday offenders, most of them nonviolent, and would normally be prosecuted by the states or others where the states would never target them for prosecution. These unfortunate individuals run afoul of very broadly drafted federal criminal statutes that can snag the unexpected and can be misused in social political advantage, or just so that the prosecutors can put another feather in their cap. They look at my conviction rate. Well, I took advantage of people, and I shouldn't have done it, but I really did it just so I look like a damned hero to my bosses. That's awful. And then let's not forget that there are 150,000 strong army of lawyers working for the Department of Justice, the FBI, the alphabet soup of other federal agencies, whose combined budgets dwarf the GDP of over 30 countries. That's just the lawyers. 150,000 lawyers in the employ of the government. Oh, my goodness. That is absolutely outrageous. 150,000? My goodness. And you think little me or some of my friends, little M's, are going to have a chance against this army of federal lawyers? It's just amazing that kind of thing goes on. So, and then there's the prison profiteers. People make fortunes catering to the taxpayer-funded bureaucracy that we know as the Federal Bureau of Prisons. Again, it's just, and the profiteers also include staff. I got to throw that in there. Your commissary funds somehow disappear. It's just an amazing. They rip people off, and they take everything from you, so you take nothing in. I mean, absolutely nothing in. You take yourself in without clothes, and they give you everything from there. So if you don't like boxer underwear that chase the hell out of you, that's made by prisoners, I believe in Terre Haute, well, you can buy it at the commissary, but we're going to jack the price up. We're going to gouge you. And for people who have lost everything, that's just an outrageous situation. But there are some things, the Bureau needs to drop the population. Its traditional number has been about 50,000. Well, it's now running about 160,000. So how do you reduce the population? Well, first of all, there are over 21,000 non-U.S. citizens sitting in federal prisons. What do you think you can do with those? Well, you can send them back to their home countries, perhaps. And then the ones I really feel bad for, that there are currently over 8,000 veterans in federal custody for a variety of nonviolent offenses. And they are absolutely, like the rest of the prison population, they are absolutely receiving minimal to non-existent medical care, minimal to non-existent mental health care. These people fought for our country. And you sentence them, some judge sentenced them to a federal prison where they get absolutely no help whatsoever. And if defense attorneys were sharp enough, oh my goodness, I'm picking on defense attorneys. Yes, I am. If they were good enough, they could use the VA Mission Act of 2018 and get those guys out of there and into the VA where they can get some adequate help. And then there's approximately 60,000 minimum to low-risk first-time nonviolent offenders in the federal prison system who are eligible for release via the First Step Act and Second Chance Act. And many are elderly and they're in poor health. This is the same organization that cannot figure out how to calculate the good time under the First Step Act. I'll tell you, these people must be, they're either idiots or they're obstructionists, because they're as old as the computer system is for the Federal Bureau of Prisons. Create a new algorithm, You can download the information you need into this algorithm and let a computer calculate it. You're not going to replace their outdated computer system, but you can calculate this stuff. And I'm telling you, a high school kid could write the algorithm to figure this out. But they hide behind it. You take 60,000 prisoners out of the system, you take 8,000 veterans, and you take 20,000 people who are in the country who are non-U.S. citizens. That's 60, 70, 80, 90, that's 90,000 people out of 160,000. So that leaves 70,000 left. It never ceases to amaze me. At the annual cost of approximately $60,000 to house one prisoner, to abuse and house one prisoner. I don't know what they're doing with the money, and I don't know how they're calculating this. But you can get 90,000 people out of that system, and you can make it with current staffing levels. Actually, at that level, they'd be overstaffed. They'd have too many facilities. They can combine facilities. They can rework the staff and get onto a reasonable basis. And finally, that this issue of is near and dear to my heart, which is overzealous prosecution of people by the DOJ who seemingly have more interest in convictions than the truth. Did you hear that? The truth. It's also my assertion that criminal defense attorneys do an absolutely horrific job of representing. They know the law, they know the rules of civil procedure, they know how to act in the courtroom, but they are absolutely blinded by their own self-importance. Instead of sitting down with people like me, people like Scott, people like Stanley, and saying, okay, so-and-so is going to say this. What do you say about that? What's the rest of the story? And helping them prepare. But they don't do that. They think they know everything. You need to come down off that perch because you're getting your butts kicked about 97% of the time. So there has to be a better way. And the better way is to work with your client to be better prepared for what's coming at them. I sat down after I got back and got released and really started thinking about things. And it's like I found instance after instance after instance of areas that should have been and could have been pursued that would have made all the difference in the world. But I didn't know that. So my guy, instead of spending some time with me, let's go through this guy's testimony. What's he going to testify to? What do you say about that? What's the rest of the story? That's a Paul Harvey thing. What's the rest of the story? And where can we come at them and discredit them? Where can we disprove what they just had to say about you? So, excuse me. I think it's critically important that this entire system be turned on its head. That these, from the prosecutors standing down, and defense attorneys stepping up, and judges giving sway to both sides of the equation, I think it's not going to get any better. I mean, there are so many things. I never want for cannon fodder for this show because there are just so many things that just make common sense that are not being done, and it's affecting real human lives of real human people on a regular basis. So that's it for today, folks, and I want to thank you for listening.